folks. Sorry about the delay. I'm going to get us started because we have a great conversation here. My name is Brian Highsmith. I have the wrong affiliation here, but I have just started recently as an assistant professor here, and I write about state constitutional history and local government law. And I'm moderating today's panel, but I'm also sort of getting things started with some brief kind of framing remarks. We heard yesterday from Professor Harris that all of us are currently living through the second redemption. So as we are thinking about our present crisis and trying to make sense of the world today that we're navigating, it seems an opportune moment to reflect on the role of constitutions, and in particular state constitutions, in the entrenchment of racial hierarchy in the authoritarian enclaves of the American South in the first redemption. And in particular, to start us off, I'm going to use Alabama's 1901 Constitution to demonstrate a point that we can return to, which is that constitutions can entrench racial hierarchy not only through electoral disenfranchisement, which is the well-known story of the Redeemer constitutions, but also, and often more subtly, through institutional design. And I'm going to focus in particular on some of the fiscal provisions that continue to remain in Alabama's constitution and affect policymaking today. So it's broadly understood, perhaps especially by those in this room, that the central infrastructure of the Jim Crow regime, the project of entrenching white political power by excluding black citizens from economic opportunity and political power, was achieved primarily through state constitutions. That was where so much of what we today know, and what was then also described as Jim Crow, was located. And so just a quick review of this history. After the Civil War, the former Confederate territories were required by the Reconstruction Acts to adopt constitutions that protected the democratic rights of political participation in their states. And particularly compared to our federal charter, the constitutional texts that emerged from those conventions immediately following the Civil War reflect an egalitarian vision of inclusive democratic equality and participation among men, including the extension of suffrage to black men, abolishment of poll taxes, positive rights to and state funding for public education. And this history today is remarkable. So just to give one example, nearly a century before Brown and Loving were decided by the Supreme Court, the U.S. Supreme Court, these South Carolina delegates depicted here drafted a new constitution that guaranteed free integrated public schools and legalized interracial marriage. But of course, this brief moment in the sun would last only a few years, and these constitutional reforms were met immediately with an organized campaign of white supremacist paramilitary political violence, economic intimidation, and electoral fraud. And by 1876, all but 3 southern states had been redeemed by white conservatives who again wielded economic political power. And so for several decades following this, this tenuous coalition or dominance was challenged often by interracial coalitions between black voters and agrarian populist reformers. And to protect their political power, white conservatives again deployed political violence and electoral fraud. But soon, and this is what I'm going to focus on, a new strategy emerged to indefinitely consolidate governing authority without ever needing to fear the consequences of democratic elections. In a wave of disenfranchising conventions that swept the former Confederacy between 1890 and 1908, white Democrats drafted new constitutions to legally disenfranchise their black citizens. In South Carolina, for example, the legislature authorized the same, where what I was just noting, the state's black codes were constitutionalized in this new convention, including a suffrage clause, poll tax, literacy requirements. This is the standard history. And the consequences were immediate. This is a depiction of, this is Louisiana, of voter registration rates over this period, going all the way up to nearly the present. And Richard Vallee, the historian Richard Vallee, has described these disenfranchising conventions as representing the only time in Western political history when a major social group has ever entered the electorate of an established democracy en masse and then was more or less democratically pushed out. More or less is doing a lot of work there. But one of the things that I want to note is that this result was the openly announced purpose of the constitutional drafters. So we're going to focus on Alabama, and depicted here is the convention president, John Knox. And so presiding over Alabama's 1901 constitutional convention that ultimately reduced black voter registration from 181,000 to 5,000 in under 3 years, John Knox announced the plan. But if we would have white supremacy, we must establish it by law, not by force or fraud. And in this goal, they succeeded. So many of the provisions that entrenched white authoritarian rule were later preempted by civil rights statutes and interpretation of our federal constitution. But there is there are many features of the Redeemer constitutions that have persisted to this day, and the one that I want to draw attention to today is the limitations on local fiscal authority that were designed, again, expressly designed to prevent the taxation of land, of white land wealth. So, for example, at the 1890 Constitutional Convention that disenfranchised Mississippi's black voters, white landowners also enacted a supermajority requirement for all state tax increases. And at Alabama's Constitutional Convention, delegates indefinitely entrenched directly into the text of the state's constitution the precise rates and bases of all local property taxes. This was to disempower rural voters and voters of color, and it removed home rule, in particular on matters of taxation, from cities and counties, stripping them from their ability to make decisions within their jurisdictions about the taxation of property in particular. And so this was this aspect of the Alabama Constitution allowed this conservative elite to block all efforts to tax their land wealth, and it has remained, it has had that effect across history. This was profiled recently in a New York Times article that is talking about the Alabama's reliance, unusual reliance on regressive fines and fees that are assessed through over-policing in black and brown communities. And it directs that, or it links that reliance on Alabama's unusually low property taxation regime, which again is constitutionalized through the 1901 Redeemer Constitution. And so one kind of point about these Redeemer Constitutions is for some surprising fact that many southern states continue to contain provisions that were added during this wave of disenfranchising conventions. For example, South Carolina's constitution today continues to authorize literacy tests as a condition for voting. And in Alabama, until very recently, the Constitution included language that allows slavery for the punishment of crime, requires that separate schools be provided for white and colored children, that is a quote from the Constitution, and also provides allocation for poll taxes. And of course, those provisions, those specific provisions, are considered dead letter under at least current Supreme Court doctrine. But there have been efforts to remove them in Alabama, for example, that were led by groups like the Equal Justice Initiative and Southern Poverty Law Center. And in Alabama, in 2004 and 2012, those efforts were rejected by voters who actually voted to keep this segregationist language, this expressly segregationist language in the state constitution, but they were more recently successful in 2002. But I want to talk about, I want to just note that in that this new 2002 Constitutional Convention that was designed and advertised as sort of addressing the Constitution's legacy of racial injustice. This is a quote summarizing it. It's a pretty limited update aimed mostly at modernizing some text and making it easier to read. It changes the specific provisions that were dead letter, but one of the things that remains in place a half century after the Jim Crow voting restrictions were repealed are these fiscal restrictions that continue today to constitutionalize Alabama's reliance on regressive revenue sources that are disproportionately assessed from minoritized groups. And so in this setting at this conference, I think this is important for us today, navigating our current crisis, to demonstrate that the present extraction of wealth from black residents in these former slave states through criminal fines and fees that are assessed through our punishment infrastructure can be understood as representing the intended effects of these long dead drafters, and that and this sort of insight about how racial hierarchy is entrenched not just through electoral disenfranchisement, but or through the design of political systems, but across our constitutions, including in our infrastructure, in provisions like our fiscal allocation of fiscal authority and other means. So I think that's, I'll stop there, and I know that let me get us set up here with our next presentation, which actually deals with many similar themes here. Let me just open this up. Yeah, I'm going to make it easier to switch places.
Thank you, Brian, and thanks all of you for being here. I'm Jack Chin from UC Davis, and I'm going to talk about a project that I'm working on with my co-author, Paul Finkelman, the legal historian from who is now at the University of Toledo. And what I want to talk about is a process of political development in the United States, which is less commonly discussed than many others. It is the development of territories, and by that I mean the incorporated territories that became the states of the United States. There's been a lot of really interesting and useful scholarship on the unincorporated territories, Guam, Puerto Rico, the Philippines, and the insular cases that flowed from them, and how those territories don't have full constitutional rights. And there has been scholarship about two of the incorporated territories, namely New Mexico and Hawaii, and how those two territories had the longest experience as territories governed from Washington, D.C., and in many with explicit rationales for maintaining them in territorial status rather than allowing them to become states, because of the non-white racial majorities in each of those states. But I want to talk about the other territories and how they fit in to the racialized aspect of American political development. And what I'm pushing back against, what Paul and I are pushing back against, is a statement by Justice Scalia, which has been repeated in other cases. And he says that when we look at racism, we should look at the bad things that states did, but the federal government was different. The federal government was not a racist institution, and I want to say that what the body of law that I'm about to discuss shows how there was a coordinated system of racism. Another thing that we're pushing back against is this is one of the many January 2025 executive orders that talks about how people should be educated and think. And we should understand that the United States was a noble society, a good society, with non-racist values that sometimes were not followed, but those were errors and deviations, not the basic principles upon which the United States was founded. And so our paper talks about how white supremacy was imposed on the territories. So I'm going to guess that all of you were forced to learn, at least in high school civics, that there were originally 13 colonies in the United States. Those 13 colonies became the original 13 states. They passed the Constitution. But now we have 50 states. Where did those other states come from? Well, 4 states, Tennessee, Kentucky, West Virginia, Maine, and maybe Vermont, so maybe it's 5 states, were carved out of the 13 colonies. So they were part of the original United States. But that means that there were 32 states that came into existence in some other way. And the way they came into existence was through territorial acquisition. They all followed a roughly similar pattern, with the exception of California and Texas. 30 of them followed a roughly similar pattern. There was territory that was acquired by a treaty. The Louisiana Purchase, the Mexican Cession. So there's some kind of treaty. Then there's an organic act passed by Congress that creates a territorial government. Then, at some point, there's an enabling act. When the people of the territory and Congress are on the same page that that territory is ready to become a state. And the enabling act says you can become a state if people in your state draft a constitution, send that constitution to Congress, and Congress deems it acceptable. And if and when that happens, we will allow you to become a state. And then, if the Constitution is acceptable, there will be an admission act that says, congratulations Minnesota, congratulations Oregon, you're now a state on equal footing with the original states. There are slight variations that I'll talk about, but our research shows that in all of the territorial creations from the District of Columbia in 1801, 1802, which didn't become a state, but it was a government that was created by Congress, until Reconstruction, free white males were the ones who were granted political power. And in the state constitutions that followed, free white males were the ones who were granted political power. So an example of this is Missouri. Missouri, the state of Missouri, was acquired territorially through the Louisiana Purchase. And there's a treaty, when countries sell their land, they don't just say, acquirer, you got it, do whatever you want with it. They tend to protect the rights of their former citizens and the people who were there. So they negotiated a provision of the Louisiana Purchase that says the inhabitants are going to be given the rights of U.S. citizens, and they're going to be protected in their property. It's not just, the space, Derrick Bell, the space traders, whatever happens to you happens. So that's how we got Missouri. The Organic Act, though, the promise that the inhabitants would be treated as citizens turned out to be not true. Free white males were deemed the basis of apportionment, and free white males were allowed to vote in the territorial government. So now we have a territorial government thanks to the Organic Act. the territorial government has power. There's a legislature, an elected legislature. It's subservient to Congress. Congress can overrule the laws passed by the Missouri territorial legislature. But for the most part, they have a significant amount of autonomy. And the Mississippi territorial law establishes suffrage, once again, for free white males, free white male citizens in this case. A couple of years later, we have an enabling act. Congress says you're ready to become a state. We want you to draft a constitution. And at that constitution, the people who are allowed to vote under your territorial law, which of course Congress knows are free white males, you're the ones who are going to draft the constitution. The constitution that comes out of that process enfranchises free white male citizens of the United States at least 21 years old. In addition, they prohibit free Negroes from coming to the state. That's another aspect that goes to Congress. And Missouri, as you know, is admitted to the Union as a state if it comes up from Congress. There were some states that didn't have elected territorial governments, but in each one of those, there was some aspect of political power that was given to free white males. So the Louisiana Orleans Territory, the Florida Territory had jury service, but that was limited to white males. Alabama and Louisiana did not have an elected territorial government, but the Enabling Act said the people who can participate in the Constitutional Convention are white males. So there was sort of an exception for California, Texas, and Ohio, where there were no restrictions on voting imposed by Congress. But when they were required to submit their constitutions to Congress before they could be admitted as states, the constitutions that those states submitted limited suffrage to free white males, and Congress said, that's fine. So I consider that to be consistent with this policy of Congress of saying that political power is going to be restricted to free white males. This policy ended with Nebraska, which was created, the Organic Act of the Nebraska Territory said only free white males could vote. The Enabling Act said only free white males could participate in the Constitutional Convention. But when Nebraska, in all innocence, sent a constitution, a state constitution to Congress in 1867 that restricted suffrage to free white males, Congress said, policies change, you can't do this. In fact, Congress passed a statute that said no territory, there were still other territories, no territory, no organized territory, can restrict voting on the basis of race. So Reconstruction eliminated this racial policy as well as slavery and a number of others. On the other hand, the territorial experience also proves the lie to the claim that Reconstruction was a comprehensive and systematic elimination of race from American law or from state law. The Warren Court, as well as later courts, for rhetorical reasons rather than based on historical accuracy, have said that the 14th Amendment and Reconstruction were designed to eliminate racial discrimination from the law. Clearly not true, not true. There were some people in the lunatic fringe, like Senator Charles Sumner from Massachusetts, who said, let us have strict non-discrimination in a wide range of laws. He lost every time. So, for example, the Naturalization Act of 1790, which was in effect in one way or another until 1952, limited naturalization to free white persons. And Charles Sumner said, let's get rid of this. Let's just get rid of free white and just say that any alien being a person can become a naturalized citizen. And that idea was shouted down That affected immigration. So we, notwithstanding Reconstruction, which supposedly eliminated race from American law, we have all kinds of racial exclusion from immigration after that. But it also affected voting. One of the things that Charles Sumner wanted to do was to have the 15th Amendment prohibit discrimination in voting. It doesn't. It's a Jim Crow law. 15th Amendment is a Jim Crow law. Why is the 15th Amendment a Jim Crow law? Because the way Charles Sumner and others wanted it drafted, it would just prohibit race discrimination in voting. Instead, it prohibits race discrimination in citizenship, race discrimination against citizens with regard to voting. And because there's race discrimination in citizenship, it flows, it carries over to this, because many states and territories allowed non-citizen voting, but only as to people who were racially eligible to become citizens. And so this, as the United States wanted to encourage immigration and populate the territory, it didn't want just anybody to come. It wanted white people from Europe to come. And it incentivized that through things like the Homestead Act, which was racially restricted, and through things like non-citizen voting, but only for whites. In the context of Reconstruction, Congress made the decision that they were going to continue that process through this restriction on naturalized citizenship. So the states were free, including through specific provisions of the Organic Acts, to encourage white immigration through non-citizen voting, but only as to white non-citizens. States did not have, the territories did not have the power, they were denied the power by statute to let non-white citizens vote. So this is a part of the federal establishment of white supremacy in the political development of the United States, a part of that story that I don't think, we have not seen it written about elsewhere, but I think it explains part of how Jim Crow was propagated across the country. And I want to say one thing about Brian's very important and interesting presentation, and that is when we think about 1870 and redemption, just as we think about the second redemption, I hope people will remember that in 1870, African American people were a majority of the population in 3 states, Louisiana, Mississippi, and South Carolina, and over 40% of the population in 4 other states, including Alabama. And so this disenfranchisement was not like disenfranchisement of Chinese, Jehovah's Witnesses, these which are unacceptable and illiberal, but it was unrepublican, contrary to majority rule, in a way that discrimination against despised actual minorities was not. And so the problem with redemption, the sin of redemption, is that it is designed to allow minority rule, as well as that it is discriminatory and objectionable for that reason. Thanks.
So, in the early morning of March 15th, 2025, Venezuelan men held at the El Valle detention facility in Jindal, Texas, were woken up, shackled, and told they were being transferred to an undisclosed location. When some asked where they were going, the guards repeatedly laughed and said they didn't know, or they told the men they were headed to another detention facility, to Mexico, or back to Venezuela. Once they were boarded onto the planes, many reportedly began to panic and begged officials for more information. The planes left that evening, stopped in Honduras, and made their final landing in El Salvador, where they were transferred to the mega prison known as CCOT, the Center for Terrorism Confinement. When they arrived at CCOT, the men were told, "You're going to die here." For months, they were fed food that seemed like it was for animals, and were regularly forced to sleep in stressed positions facing the wall, with their hands behind their necks. They were regularly beaten by officers and the prison director himself. Extended acts of torture took place in an isolated zone called La Isla. Some men left CCOT with fractured ribs, fractured fingers and toes, and marks from their handcuffs. After his release, Juan Jose Ramos could still barely see through one of his eyes from all blows to the head. Many of those incarcerated, Ramos said, tried to end their lives inside. They said, "I'd rather die or kill myself than keep living this experience." According to Isabel Penalosa, the uncertainty of not knowing why they were there, why they had been taken to that country, why they had been brought to a terrorist prison, was extremely difficult. And even after they were finally released to Venezuela on July 18th, as part of the prisoner swap, Wilmer Vega Sandia had still not fully processed that he was free. According to multiple reports, approximately at least half of these, around 250 men who were imprisoned in El Salvador, insisted that they had come legally to the United States. With advanced government permission, they crossed at an official border crossing point. Many of them were working in the United States in a variety of professions. The overwhelming majority had no criminal convictions or even charges, and none of the men appeared on any Venezuelan gang databases. So I think behind the physical brutalities these men endured were a number of procedural cruelties that are clear to us. These renditions were authorized by President Trump's invocation of the Alien Enemies Act in response to the ostensible invasion of the United States by the Venezuelan gang Nicaragua. And Section 3 of the executive order specified, in a notable departure from the kind of already repressive Alien Enemies Act, that alien enemies would be, quote, subject to removal to any such location as may be directed by the officers responsible for the execution of the order. The proclamation was made public just before the first flight took off. So as Justice Sonia Sotomayor described the government's actions, in what can be understood only as covert preparation to skirt both the requirements of the Act and the Constitution's guarantee of due process, DHS began moving Venezuelan migrants from ICE detention centers across the country to the El Valle detention facility in South Texas before the president had even signed the proclamation. So this was a kind of premeditated effort to remove these men from recognition. So even when, in full knowledge that a class action suit was being brought in anticipation of this kind of covert action, the administration loaded the detainees on planes in an apparent attempt to rush the plaintiffs out of the country before a court could decide whether the executive order was lawful or whether they were members of Nicaragua. As I'm sure many of you know, a district court held in an emergency hearing that afternoon and issued a temporary restraining order on any removals for 14 days. But with the planes already in the air, the government refused to turn them around on the logic that they were not bound by an oral order. And once imprisoned, the men were suspended in what's been called a legal no man's land. So according to the Salvadoran government, the Venezuelan men remained under U.S. jurisdiction. But the U.S. State Department disclaimed any responsibility for the men or the conditions of the prison they were ensnared in. Even Kilmar Armando Abrego Garcia, who the government acknowledged was sent to El Salvador due to an administrative error, remained suspended in the country for nearly 3 months. And it was only days after the Supreme Court actually ordered the government to facilitate his return that Attorney General Pam Bondi insisted that it was up to El Salvador to return him, even as in the same Oval Office meeting, President Nayib Bukele of El Salvador said he did not have the power to return Garcia to the United States himself. 2 months later, Bondi finally presented El Salvador with an arrest warrant for his return. But even now, his status remains is being negotiated. The government has expressed interest in deporting him to Eswatini or Ghana. So Chief Judge James Boasberg of the District Court for the District of Columbia compared the situation of these men to Joseph K. and Kafka's The Trial, which opens with his arrest in the middle of the night for no apparent reason beyond the government's assurance that it had made no mistake. In this case, the government rested its position on virtually no evidence beyond the president's own authority to make unreviewable factual determinations. For some officials, it was even the dearth of evidence that proved the men's guilt. As one ICE agent said, quote, "The lack of specific information about each individual actually highlights the risk they pose and demonstrates that they are terrorists with regard to whom we lack a complete profile." So these renditions have justifiably alarmed much of the legal community. As Judge Boasberg concluded, our legal tradition is wholly incompatible with the establishment of a network of overseas prisons shielded from the Great Writ by the facade of foreign control to which the government routinely exports detainees without due process. But the rendition of these men bears a striking resemblance to a hallmark of 19th century legal tradition, the rendition of free and enslaved Black Americans under the fugitive slave laws of 1793 and 1850. In an echo of this history, some of the seat-top detainees and their families refer to the experience they endured as a kidnapping, a term that abolitionists used to describe both slavery and the fraudulent capture and sale of free Black individuals under the federal laws designed to protect it. So, because 19th century victims of kidnapping had no appeal once they were sold into slavery, there's no actual kind of accurate count of how many spent their lives in unlawful bondage in this manner. It took Solomon Northup, the subject of the narrative 12 Years a Slave, more than a decade just to send a letter to his wife in New York. After he was drugged and sold in Washington, D.C., his attempts to assert his claim to freedom were met with a beating severe enough that he was almost unable to speak, he said. And children, poor Americans, and residents of border states, like Delaware, Maryland, and Pennsylvania, were particularly vulnerable to kidnapping by both force and deceit. Two brothers, Peter and Levin Still, for instance, were abducted at the age of 6 and 8. Levin died in slavery. It took Peter 40 years to purchase his stolen freedom. And these are just the names we know. So, like alien enemies today, those dragged before a court as fugitive slaves had few procedural rights. Under the Fugitive Slave Act of 1793, this process of rendition was made summary in many ways. As Sandra Grusin has argued, the Fugitive Slave Act simply did not contemplate the due process rights of Black Americans, and nor did it take any steps to ward off the very real incentive the law produced to abduct free Black individuals and profit from their sale. So for that reason, the consequences of rendition did not simply mean the return of formerly enslaved individuals to the place of their enslavement to face whatever brutal punishment awaited them there. For free Black Americans, rendition, like kidnapping, might mean removal to a place they had never been, a place entirely foreign to them. And for the formerly enslaved, too, rendition often meant sale to a far removed location, because enslavers had little reason to hold on to human property that was liable to run off. And for anyone rendered to the South, there was really minimal possibility of finding a legal remedy in a region that precluded Black testimony altogether and tightly circumscribed the legal rights of enslaved and free Black individuals alike. So of course the Supreme Court upholds these procedural defects in Prigby, Pennsylvania in 1842, regarding the forced removal of Margaret Morgan and her children from Pennsylvania to Maryland. And writing for the court, Justice Joseph Story upheld the fugitive slave law and discovered in the Constitution the existence of a positive, unqualified right on the part of the owner to the immediate possession of the slave. Paul Finkelman has described Story's discovery of this kind of self-help principle in the Constitution as an open invitation for the kidnapping of free blacks. As Justice John McLean asked in dissent, may not the assertion of the master be erroneous, and if so, how is his act of force to be remedied? The colored person is taken and forcibly conveyed beyond the jurisdiction of the state. And in fact, in the case of the Morgans, the assertion of ownership was erroneous with respect to her children who'd been born on free soil, and it was questionable with respect to Morgan herself, who was the daughter of a couple who'd been informally declared free. And then the Fugitive Slave Law of 1850 only further eroded whatever highly delimited procedural rights remained for Black Americans, excluding the testimony of the accused and precluding any form of appeal or state procedure that might interfere with the right of removal, including presumably the writ of habeas corpus. The Fugitive Slave Law also offered asymmetrical protection to enslavers. Newly appointed federal commissioners received a doubled fee for rendition rather than release. The law also deputized the broader public, subjecting anyone who assisted an alleged fugitive to a prison term or a fine. Any federal marshal who's even allowed someone to escape with or without their consent was liable for the full value of that fugitive service. And in 1858, the court again upholds the constitutionality of this law. Chief Justice Robert Taney found it to be, in all of its provisions, fully authorized by the Constitution of the United States. So a number of scholars have noted the kind of uncanny resemblances between rendition under the fugitive slave laws and deportation of undocumented immigrants in the 21st century. And many such scholars examine these resonances in terms of both kind of federal action and state-level resistance it has provoked. Resistance that includes personal liberty laws and vigilance committees in the 19th century and in kind of sanctuary cities and humanitarian aid at the border today. And both fugitive slave rendition and immigration laws, they say, raise questions of federalism that arise as a result of the presence of individuals within state borders who have been in some way rendered unlawful by the federal government. And most importantly, a number of these scholars note, undocumented immigrants share one critical commonality with antebellum fugitives. This is a quote: a desire to make or retain a home on free soil and not to return from whence they came. So we talked a little bit about Justice Kavanaugh today. Even Kavanaugh, in diminishing the rights of undocumented Americans last term, still said he recognized and fully appreciated that many, not all but many, illegal immigrants come to the United States to escape poverty and the lack of freedom and opportunities in their home countries and to make better lives for themselves and their families. At the same time, scholars are quick to note that these resemblances do not minimize the differences between enslavement and deportation. Procedurally, deportation functions differently from fugitive slave rendition. And the federal government's enforcement of property rights would seem to raise different questions than its enforcement laws about permissible entry and presence. And finally, this is a quote: being exiled to slavery is different from being exiled to another country. But I think that the specter of rendition and other forms of third country removals under the second Trump administration forges a tighter bond between the fugitive and the undocumented. Rendition, writes Christopher Lash, is one of the legal mechanisms for delivering bodies back across borders, one that has been used as a weapon to counter the free migration of laborers of color. In both cases, fugitivity serves as a racialized condition that federal law creates, and its punishment is exercised in the banishment to a legal abyss, whether that be a southern plantation or a foreign prison. Much is unknown. Numbers lost their liberty and their lives in slavery. So does the possibility exist that scores of individual lives may be irretrievably lost in the Trump administration's pursuit of rendition. In both the 19th century and today, these potentially irreversible removals seem to require little more evidence than the enslaver's word or the president's proclamation. Nor is the threat restricted to the undocumented, just as the possibility of rendition and removal was never restricted to the formerly enslaved. Sotomayor heard in the government's argument in Nom via Abrego Garcia last term that it could deport and incarcerate any person, including U.S. citizens, without legal consequence, so long as it did so before a court could intervene. And Boasberg also concluded that absent judicial intervention, the government could snatch anyone off the street, turn him over to a foreign country, and then effectively foreclose any corrective course of action. Trump himself has mused about the possibility of sending American citizens, homegrown criminals, to a place like CCOT. Abolitionists articulated a similar fear that anyone was liable to be snatched by kidnappers. A group of more than 300 Black Chicagoans urged that the tendency of the Fugitive Slave Bill was, quote, to enslave every colored man in the United States. And to someone like Wendell Phillips, white Northerners were equally at the mercy of prowling kidnappers because there were multitudes of white as well as Black slaves on Southern plantations. Slavery was an institution that was at once predicated on race and amenable to creative constructions of what racial identity meant. And so abolitionists were often want to note the presence of the white slave in the South. And more broadly, everyone's freedom was menaced by the introduction of such a summary pathway to unfreedom. This is something that Jamal Hui argued somewhat recently in the New York Times. So there is another story to be told here, a story about resistance to these coercive and brutal actions by the federal government and its agents. Resistance at the individual, local, and state level, with the potential to kneecap the policy of rendition. But that story begins in the yawning legal abyss that the law itself has created and continues to create in producing racialized forms of fugitivity that invite not even the violence of the criminal state, but the force of a different kind of power altogether, the sheer vertiginous power to remove and condemn to a place of no return.
Hello, my name is Mark May. I'm an immigration attorney and 2019 graduate of the CRS program. My paper is about the English language requirement. He stole my credentials. But my paper is about the English language requirement of naturalization and what's I would call white naturalization. So the starting point is obviously scholarship that's already talked about white naturalization and the white person requirement. White by law by Professor Henny Lopez. And so, as we know, for 162 years of U.S. history, being a white person was a requirement of obtaining citizenship. And per Professor Henny Lopez, by the Supreme Court's decision in Fins, the court had rejected a scientific rationale in favor of a common knowledge rationale. But as John Turanian, in his study Performing Whiteness, found, common knowledge might have been a misnomer. The court rejected a skin color test, which would have been all too simple. It rejected also, without considering a geography test, saying these people are of a certain race. And in his words, the court instead accepted those as white insofar as their character, class orientation, language, ability to intermarry, and a host of other traits that had nothing to do with intrinsic racial grouping proved that they were white. So in that context, in the US context, the content of whiteness is the capacity for assimilation and Anglo-conformity. So I want to trace the English language requirement as an example of this Anglo-conformity model and as the survival of racial citizenship, even though no longer a white person is a requirement. And I think it's no coincidence that in 1906, when this requirement was created, only white person or a person of African descent could become a citizen. So I view the English language requirement as a broader part of the Americanization movement of the turn of the 20th century. And this history shows that the colorblind approach to discrimination well preceded the late 1900s. What I label white naturalization is a theory that rights are recognized insofar as they naturalize white supremacy, which is to say they establish racial exclusion and racial subordination as scientifically objective and a desirable reality. The law sanctioning ordinary English as a natural common good is an example, given the colonial history of English. And as such, I argue that the English-only laws, at least how they exist now, can never be considered race neutral. So today I just want to start with my thoughts about the intersection of race, language, and the law, the history of the English language requirements, and then equal protection jurisprudence, and as time permits, my thoughts for future research and this conference. So I've been interested in themes of race, language, and the law for quite some time. I'm not sure if I'm closer to understanding that intersection, but I am closer to understanding what interests me about it. And so as a personal note, I think it's obvious for me how language has formed a part of identity. First, it begins with the name. My father's name is Marco, mine is Mark. He was born in Ecuador, a naturalized US citizen, but I was anglicized from the start. My father didn't make a conscious effort to teach me Spanish. He would say that I rejected efforts to learn Spanish, but I think the point is the same. If being bilingual were valued in American society, then I would have learned at a very young age. But American society values conformity, homogeneity, and in that sense, whiteness. For me, learning Spanish was a conscious effort, and I see how it has affected my life. For me, being able to connect with others, particularly my clients, to literally thinking with the different terms, with a different grammar, and part of a different cultural milieu. And finally, as a way to assert difference against the grain American model of assimilation. So, most importantly to me, it's been a way to connect with my family, and I'll never forget when my grandmother compared me to the small kid who would walk around her kitchen with his nose pinched, to someone who she saw as Latino. So, my experience with learning Spanish, which of course is a colonial language, led me to think about race and language per se, which is the symbolic system of communication that undergirds law, literature, history, and human experience, including knowledge and identity itself. And so when I think preliminary about race and language, I think about how terms like white, black, yellow, brown, as linguistically solidifying the connection between skin color and race, even when a phenotypical perspective leads to other important considerations like hair, facial, body structure, and as I would say, language. I think of how terms like Latinx, African, Asian, Indian also show how there's an intimate relationship between geography and territorial divisions and racial identity. And then I think about how language and colonization, and how imposing language, like imposing religion, was a way to impose a worldview, a subjective worldview, and change that. And then I think about how language speaks through us as much as we speak through language, and in a large part determining our unconscious and conscious realities. So in turning to the English language requirement, I have a few things to say. First, while there's a liberal perspective that the US has always been linguistically plural, unfortunately I don't think that adequately tracks reality. Although the Constitution never established English as the United States language, it was probably because the founders never questioned the status of English in United States society. At the beginning of American independence, most of the immigrants came from Germany, France, Netherlands, and these nationalities were not accepted either. The ways these immigrants were treated was, in every sense, racialized based on language, religion, and culture. Benjamin Franklin worried that German influence would overthrow Anglo-dominance. He said that they were stupid and doubted their ability to understand Republican government. Thomas Jefferson doubted the ability of French speakers in Louisiana to govern themselves, but it was only when Germans, French, Dutch, and other Western and Northern Europeans proved their intent and their ability to assimilate that they were accepted in United States society. And so today, while many still say that there is no official language to the United States, I think the Naturalization Act of 1906 shows that the U.S. has symbolically declared English as part of its identity and materially limited the rights of foreigners for that to be contingent on their ability to assimilate and learn English. So whether one believes the liberal narrative that the U.S. has always been a pluralist society, or the conservative narrative that the U.S. has always been American, it may be surprising that these laws seem to have come only within the last century. While some historians point to the 1980s and Senator Hayakawa's proposed official English constitutional amendment, I understand the 1980s in the current moment as a product of the Americanization movement at the turn of the 20th century, which was a campaign to assimilate immigrants, teaching English, civics, and middle-class values. However, whether it was the turn of the 19th century or the 1980s, it seems that each time these efforts were a reaction to large-scale immigration that threatened the social status of elites and the status of white America. So this brings me to the Naturalization Act of 1906 itself. And although there was no English language requirement before, it seems that district courts and federal judges would often impose that requirement on people and test their ability to speak English before they gained citizenship. The impetus for the 1906 Act was the fact that there was allegedly a lot of fraud and lack of uniformity. The Act not only imposed the English language requirement, but also created the Bureau of Naturalization and Immigration to standardize the process. And so it was Theodore Roosevelt in 1905 who established a commission to analyze naturalization laws and suggest reforms. And the commission quickly called for English language requirements. Quoting the commission, "If an immigrant does not know our language, he does in effect remain a foreigner." Continuing, "He cannot understand the questions which the court may put to him when he applies for naturalization, nor read the Constitution which he swears to support. When afterwards he votes, he cannot read his ballot. The Commission is aware that some aliens who cannot learn our language make good citizens. They are, however, exceptions, and the proposition is incontrovertible that no man is a desirable citizen in the United States who does not know the English language." In 1906, the House Committee quickly approved a bill requiring naturalization applicants to not only understand English, but speak, read, and a literacy test on English. That was modified on the House floor, and the version that passed stated that no alien shall hereafter be naturalized or admitted as a citizen of the United States who cannot speak the English language. But I think it's what Theodore Roosevelt said in 1919 that is very telling. A longer quote, but he says, "We should insist that if the immigrant who comes here in good faith becomes an American and assimilates himself to us, he shall be treated on an exact equality with everybody else. For it is an outrage to discriminate against any such man because of creed or birthplace or origin. But this is predicated upon the person's becoming in every facet an American and nothing but an American." He continues, "Any man who says he's an American but something else also isn't an American at all. We have room for one flag, the American flag. We have room for one language here, and that is the English language." And so, if you don't know much about Roosevelt, he seems to be Donald Trump before Donald Trump ever was born. He was an outright advocate of American imperialism, advocate of cultural Native American genocide, and racial hierarchy, all while claiming he would never judge someone by the color of their skin. I could read you quotes, but they're just absurd, and I'm going to skip them, but you can see himself, the discourse is ridiculous, combined with the fact that he proclaims to be colorblind. But in short, knowledge of the English language was separated from its colonial past and seen as an objective, meritorious policy. While the Commission acknowledged that some people could be good citizens even if they don't know English, and while the law acknowledged that some people were physically incapable, it was still made a requirement. And so while Congress initially rejected a literacy test, by the Internal Security Act of 1950, it amended that provision to require an understanding of the English language, which included the ability to read, write, and speak words in ordinary usage in the English language. This law also created the modern civics requirement, which could be its own topic on its own, but in short required individuals to learn U.S. history and civics, which you can imagine involves a very distorted view of U.S. history and democracy. In 1952, the law that eliminated racial requirements to naturalization maintained and reaffirmed the English literacy requirements. The most recent change was in 1990, which created an age-based exception and a disability waiver. But regardless, or perhaps in light of these exceptions, learning English is a highly symbolic act of membership in U.S. society. It should be noted, though, that in recent statistics from 2022, 93% of applicants passed the English language exam on their first try. The reality, in my opinion, or with these statistics, is that the exam is not very hard, which also discredits its utility in terms of assuring that everybody is going to speak English. But at the very least, it places a symbolic deterrent for thousands, if not millions, of people who fear that their English is not good enough to become a U.S. citizen. So this brings me to the essential question, which is, what does English only have to do with equal protection? The simplest retort is that any obligation to learn English applies equally to everybody, so what's the big deal? Some aspect about this study or criticism that I want to make is that it seems not controversial at all for most Americans to say that Americans should speak English. In polls of U.S. citizens, upwards to 70 or 80% of citizens believe English should be the language of the United States. It's as uncontroversial as in Germany that Germans should speak German. But this history aside, what is the problem? I think that from a practical perspective, that some people, while not more inherently capable of learning English, have the time, resources, and background to make that easier. For example, a European student typically has a background in training in English, and even if they didn't, given the similarities of European languages and their influence on one another, those individuals have a much greater opportunity and ability to learn English, as at least compared to other people, for example, a rural person from China. So turning to jurisprudence, one can see a regressive history of language rights and the familiar story that the Supreme Court denies the existence of civil rights absent an explicit intent to discriminate on race. The case I want to discuss is Meyer versus Nebraska from 1923. In 1920, Nebraska was the first state to pass a constitutional amendment, making English the official language. The year before, the legislator passed a law criminalizing the teaching of any other language but English to any student who hadn't reached the 8th grade. A person who was convicted for teaching German and appealed that decision. While affirming that regulating English was within the police power of the state, the Supreme Court overturned the conviction on rational basis review. It stated that the protection of the Constitution extends to all, to those who speak our languages as well as to those who are born with English on the tongue. Perhaps it would be highly advantageous if all had readily understanding of our ordinary speech, but this cannot be coerced by methods which conflict with the Constitution. A desirable end cannot be promoted by prohibited means. And so while this decision could be seen as favorable, the Supreme Court explicitly agreed that having a homogeneous society with one language is desirable. It also explicitly approved that aim and the power of the state, and it referred to English as our ordinary speech. By employing rational basis review, the court implicitly held that discrimination on the basis of language was not a suspect class. And I think the key aspect of the decision are twofold. First, that this was a criminalization for the right of a parent to control their child's education, which was ultimately framed as a privacy right rather than a cultural right. If this was not a criminal matter, if this was about positive rights and rather than negative rights, I fear the court would have likely gone the other way. And one of the true death knells in the court's decision was that the state didn't outlaw teaching ancient languages, which allowed this court to say that this was an arbitrary aim because if you were allowed to teach ancient languages, that's going to distract and take students' times. It doesn't make sense that you're only outlawing modern languages. If it outlawed both ancient languages and modern languages, again, the court might have gone a different way. So there's other cases about the Civil Rights Act, about people suing for the right to be provided English language education, and that was Lau versus Nichols. But years later, Scalia, in a 5-4 decision in Alexander versus Sandoval, said that no, these people don't even have a right to sue in the first place. And I'm not going to go over the whole decision, but his decision was basically that absent intentional discrimination, there's no private right of action in that section of the Civil Rights Act. So there's other aspects of the precedent and law that I want to analyze, including the Voting Rights Act, which outlaws the literacy test and mandates that states provide voting materials in a person's native language, which then raises the question of if literacy tests are understood to be discriminatory and a person has a federally protected expectation that they will receive voting materials in their native language, what is the point of the English language requirement? But attaching the English language requirement on the basis of equal protection may be exceedingly difficult, even without taking into account the plenary power doctrine. First, when racial intent is defined narrowly to understand discrimination as line draws on the basis of race, color, and national origin, it will certainly be rational basis review. And I think in this case, it might be even a struggle to show a disparate impact. One could look at the 4 to 6% of individuals that don't pass and see what that tells, if there's patterns, but I think the important story is all the people who decide not to even try to be citizens because they're not confident in their English language ability. So I think it's an easy test precisely because the federal government doesn't want this type of litigation. It wants English as the official language, even if it's only a symbolic gesture. And this brings me briefly to the critiques of the Equal Protection Doctrine by Charles R. Lawrence, titled The Hidden Evil of Equal Protection, that I'm sure many are familiar with, which reframes the test towards symbol, whether a symbol intentionally or not has racial significance. And I think in this view, English, of course, is racial. It hadn't been associated with one specific European power and imposed through colonization, and later with the United States, which employed its own tactics of colonization to dispossess natives of their lands, employed forced assimilation to erase their worldview and force them to learn English. So in terms of my thoughts for the future, I think that analyzing this from a First Amendment perspective might be fruitful. There was a case that got to the Supreme Court where the Ninth Circuit overruled Arizona's mandating that all of its services are performed in English, but the person who sued had changed from her job into the private sector, and so the Supreme Court just voided that as moot. But I think the First Amendment grounds might be an easier way to get to strict scrutiny, but even so it would be challenging. And then I want to conclude with some theoretical thoughts that are relevant to this conference and what I think can go towards a critical theory of race and rights, and I appreciate anyone's critiques or criticisms on these preliminary thoughts. First is the concept of implicit bias. I think it's impressive how far the scholarship has had, and specifically its impact on the courts, where judges themselves are being warned and taught about implicit bias and unconscious bias, but it feels like it's allowed judges to say they've considered their biases to ultimately make the same decision. While arguably outdated, I think it's important not to lose sight of the psychoanalytical perspective, which is admittedly confusing and non-empirical, but to the degree that implicit bias focuses on supposedly normal mental processes about categorization, I believe this supports and does not disturb white naturalization. To say that mental heuristics necessarily lead to racial stereotype is incomplete without focusing on the everyday cultural symbols that reaffirm whiteness. And then second is the concept of rights discourse. CRT originated apart from the divide between CLS about the usefulness of rights. While I agree that the language of rights has had immense power for individuals to challenge racial subjugation, an exclusive focus on rights is incomplete. Liberation struggles have already given us supplementary ideologies for which we can understand how to restructure law at a structural level. And I think of abolition, reconstruction, and reparations. Do these legal discourses not have similar power to unify subjugated people and reframe rights? And to exclusively focus on rights, especially individual rights, I believe faces roadblocks and the co-option of anti-discrimination from conservative forces, because, again, my thesis I hope to prove is that rights are only recognized to the degree that they affirm the white male subject. And that's a dilemma of interest convergence that has yet to be resolved. Thank you.
So we've got just about 15 minutes left, and there's such a wealth of wisdom in this room. I think I'd love to open it up directly or immediately to either questions or reflections from the audience, so we can have a conversation.
Well, thank you for this really interesting panel. I had, I guess, a comment for Brian and Jack, and then also just a question and thoughts for Emma. I want to make a plea to abandon the term redemption. I think we've rightly rejected other language of the white supremacist Democrats, right? We don't talk about carpetbaggers, we don't talk about scalawags, ignorant Negroes, we don't call Reconstruction the tragic era. So we don't think we should accept the self-description of terrorists and white supremacists as redeemers, or an era of violent reaction, revanchism, counter-revolution as a redemption. And also, I think simply put, the term redemption can't be redeemed or reclaimed, and it doesn't read to the public as a negative term. So it becomes really problematic when we talk about a second redemption. A lot of people hear that as a positive. And so anyway, just a plea to rethink that one. But I love your paper, and I was thinking about today was announced that the Trump administration is thinking about sending Abrego Garcia to Liberia, and that apparently Liberia has maybe agreed. to take him, and I was thinking about not just the connections between contemporary rendition and fugitives in the north, or people who were kidnapped in the north, but also just the removal or the movement to remove free black people from the United States and send them to Liberia, with, sort of known as the colonization movement. It was kind of a neutral terminology for what is really a movement of racial cleansing and deportation, rendition, and so I'm wondering about how you think about that and these different things that are contemporaneous, how you think about them in relation to one another. But I think it's a really important work. Thank you.
Yeah, I mean, it's such a good question. I think I mentioned some of these scholars who've been thinking about these connections, and I think like Parker, is that name right? Yeah, and Making Foreigners kind of gestures towards this connection, and so does Dan Kanstrom, which is like this idea that, but they both kind of mention it in passing, which is that these, the real push for, the colonization movement, which was this kind of racist policy of kind of voluntary, quote unquote, voluntary removal.
I was just to say that some is voluntary and some are involuntary. Some states, right, pass laws that say anyone who is free or freed has to leave the state immediately, or we're going to be involuntarily removing them all.
Well, yeah, I mean that's interesting, because so that is kind of separate from the colonization project. It's more like baked into state law, and it's more state to state removal, right? So there are actually
some of it's true, some of it's like
that's interesting. I wasn't familiar with, because I've always been thinking about that as those kind of state level policies as really just kind of exile and forced removal from the state, or if you were kind of unlawfully present in the state, so many days after you've been manumitted or freed, that you might actually be re-enslaved, because you would then be jailed and sold to pay for the jail fine. So I need to look into that kind of more. Yeah, but yes, I think there's like a really kind of rich connection there, and I think the involuntary piece makes it even more important, because that's really what's at stake in these the kind of involuntary and almost processless removals. So thank you.
Yeah, I just, thank you so much. This was so enlightening. I work in immigrant justice for more than 30 years, so this is very interesting to me. I'm not a law student or anything. I think it's interesting to think about also just how, so when we talk about rendition and enslaved, but it's like, and then it's replaced by jails, and then the detention centers, right? So it's like, right now there's, I think, 1.25 million people in prison, state and federal, so that's like rendition as well. There's over 60,000 people in detention right now. I just did a visit a couple of months ago to Louisiana to 3 detention centers, and people are just disappeared, right? So there's like this deportation to third, whatever, countries, and then also to people's home countries, but then also just people are disappearing. Like they're like, I've been here, I have no contact, I know nothing about my case. And folks with or without criminal records, I don't want to forget those folks, and the folks who served time in prison who are here. Like I spoke to this woman, she's like, I have no vehicle to get out of here. At least when I was in prison, I had a way to make a complaint, and there was somebody, but here I am in a private prison. So anyway, I just think that might be another area to explore in terms of the piece, but I think it connects very nicely to our 2 speakers before in terms of how did these southern states also then use prison, right, as a way to, for racial enslavement and elimination.
Let's start in the back.
Okay, hi, my name is Meghna. I'm an undergrad here at UCLA, and I just wanted to share some reflections on something that Mark was sharing about intersections between race and language. I just wanted to say I really appreciated what you shared, and especially your personal connections to the issue. It just really brought me back to my own personal connection with that area, and with my naturalization process, my parents' naturalization process. It just like made me really like think back and reflect on them going through like the civics test, and I just remember like watching YouTube videos with them on like what information they need to know, and sharing like my own knowledge from AP Gov, like what do you need, what like facts and knowledge can I give you to help you pass this test. And I think that just what I wanted to, I guess, inquire about, or maybe like add another layer, is I was just, as I was reflecting, thinking about like the additional nuance of like class in this dialogue, in this conversation about like thinking about my own parents. Obviously they were educated outside the United States in India, and part of the core curriculum in Indian schools is to like learn English as like one of the primary languages. So when they immigrated here, they already had like fluency in English, and that I think made it a lot easier to go through the naturalization process. So I was like thinking about how like other immigrants from other parts of the world with different socioeconomic statuses, like how that difference can occur even in like a bunch of like non-English speaking communities, how like that additional layer of class can make it more difficult for certain people from certain areas in the world to access like citizenship and naturalization. So that was just kind of what I was thinking about. I was wondering what your insights were into that.
Yeah, no, thank you for sharing your own personal story as well. I mean, I didn't touch as much on that, but I kind of wanted to talk, when I talked about the practical nature of how it's easier for some people to meet this requirement than others, and I think that, you know, the example of India and other countries that were also colonized by England also shows like those are the connections that are formed, and even it's easier for those countries to, you know, form connections with each other, and it's going to be harder for those that don't have any experience with English. In terms of the class perspective, and I think that obviously goes towards race itself, and I think the other presenters talk about that, but also in Turanian's article he talks about how, yeah, class consciousness, and that's a very essential aspect of race. And all I can add in terms of like the practical aspect is like, yeah, to learn English takes resources. You know, it takes financial resources, it takes time to take your day that you could be working to learn English. And so it's obviously a lot harder for a lot of people, and I think that's what happens to a lot of Latinx people in the United States, that again, it's kind of more of a fear that they can't learn English, even though again, in just my own personal experience and many people who pass that exam, it's not a very hard exam. I think it's that deterrent factor, and a lot of people doubting themselves that they can do it and thinking, oh, I'm going to have to take hours or weeks to study, when they just don't see that as something worth their time if they think they're going to fail at the end. And so I think it'd be interesting to talk to people about that and gather that type of data to go into the considerations about why they might not take the exam, even though there are millions of LPRs, and I think a lot of them are eligible for citizenship but don't apply for citizenship, and I believe because of this reason. Thank you. I'll think more about that.
I just had a few comments related to you know, several of the pieces. First, you know, Brian, I'm writing this essay about the Mississippi Constitution for the Brennan Center for Justice. They're doing a series on all of the state constitutions, and Mississippi is one of the few that has not been modified since 1890, when it was written by the white supremacists who overthrew the biracial government in Mississippi around 1875. And I do think it is important to find a new term rather than redeemer, particularly for people on the outside who don't know the negative connotations. So I would have to second what you said about that in that regard. But it is really a challenge. I also thought that the quote from the Speaker of the Alabama House about using law to reestablish or to establish white supremacy as opposed to force or violence is really powerful. I mean, this goes to one of the central tenets of CRT, that you can deliberately use law to establish such an evil like white supremacy. The law is not incompatible with racism or the evil of racism. So yeah, I think that was great. And I also think that this issue of white minority rule is one that we don't talk a lot about in the context of the United States. When we hear white minority rule, we often think of South Africa or Rhodesia. But Mississippi was majority black until the 1930s, and there are many states, of course, at this time that are either majority black or have a very large black population, and the effort to reestablish white supremacy was in part due to the fact that there was an interest in reestablishing white minority rule. And so there's a real opportunity to talk more about that as a concept in America in this whole context. And also, Emma, to the previous point we were discussing about Liberia, Isabel Wilkerson's book, The Warmth of Other Suns, this also describes the Great Migration as a form of exile. From my own personal perspective, my family is from Mississippi on both sides, and my father's family moved to Cleveland, Ohio. My mother's family moved to Chicago, and they came back to Mississippi a year before I was born because Mississippi was home. And so I was the first person since my grandmother was born to be born in Mississippi. And she was born on a plantation 50 years before I was born in a formerly all-white hospital in Mississippi. And so the theme of exile can really be extrapolated in many ways, including the movement to Liberia and also the Great Migration.
Very quickly, and then I see another question, which will probably conclude our time. On this sort of how do we describe these state constitutions, this wave of disenfranchising constitutions? We often, or the term redeemer was the term that they used, and so which is one reason why we should reject that and not accept that premise. And I do want to note that another term that they used was white supremacy. So we could call that, and again, let me read this quote from John Knox. But if we would have white supremacy, we must establish it by law, not by force or fraud. So I think these are, white supremacy has become sort of seen as, but this was how they described their project. And so that might be an alternative term that we could use to describe. And then the final point on this, I actually did want to spend some more time on this point, but wanted to move quickly. But this sort of point about the nature of law and kind of that quote, which I think about all the time, is really important to and challenging, I think, for us to reflect on today in a moment where rule of law is under threat, but also even just interrogating the nature of law and going back to these sort of the consequences of law that emerges from these processes that have never been inclusive, and so just kind of inviting reflection on that, and I'm hoping that's something we can continue to do in these spaces. I see one final question for us today.
Hi, my name is Stella, and I'm a third-year law student at UCLA Law. I'm also an immigrant youth. I'm a leader who is an immigrant youth in the immigrant rights movement here in California. The question I want to raise is, decoupled from white supremacist standards of full citizenship, what's full citizenship? Also, I want to say, to the difference in learning and learning English. I had to leave behind my language, and then I turned out to be one of the only 2 students in my high school that passed the citizenship test given in my civics class. So yeah, while I was undocumented, so yeah, you're right. But yeah. So what's full citizenship then? The second question I actually have that other panelists could probably answer is, what do you think of amnesty for immigrants and parents of DACA recipients? I'm trying to argue in a paper that against the guilt that they've been wrongfully made to feel, and not to reinforce these white supremacist standards of citizenship. But it's going to take a lot of thinking. I appreciate it.
Would there be any final thoughts? I do see we're a little bit over time, so I may invite us to continue these conversations during the break. But I would love to, unless there.
Well, we'll just say those are both excellent questions.
Absolutely.
I don't have an answer, especially to the first ones. I think even asking it is like, how do we even think about a concept like citizenship outside of that framework? is such an important question. So I appreciate you asking. I don't have any good answer to it, but it's like, I imagine the kind of constructive work of a conference like this one where scholars like you yourself are looking into.
Free question for all.
Well, thank you. We'll take that into the break. Thank you again for attending us.